Order, and welcome everybody to this meeting of the Working Pensions Select Committee in our inquiry into the Norton pension schemes and the Fraud Compensation Fund. A warm welcome to the two witnesses on our first panel, and I'm going to ask both of you to tell us briefly who you are, starting with Dominic Harris.
Certainly. I'm Dominic Harris. I'm the Pensions Ombudsman, have been for just over a year now, and prior to that I was a partner at a private practice law firm in the city specialising in pensions.
I was the Pensions Ombudsman until January 2023, and I was the Pensions Ombudsman during the period, obviously, of the Norton case. I'm, through the sad demise of the previous chair, Caroline Rooks, I took over as the interim chair for this year. I'm also the Deputy Pensions Ombudsman, and I took on that role to deal with the aftermath of the dishonesty cases where I'd held oral hearings, and also to deal with any conflicts that Dominic may have. In addition to that, I'm been appointed to the determinations panel of the Pensions Regulator.
Your appointment as chair, when did that take effect?
January this year.
January this year. Thank you. Can I then put the first question to Dominic? If a pension scam victim complains to the Ombudsman, what should they expect to happen now?
Well, if I may, I'll start wide and then narrow it down. So the Pensions Ombudsman is there to deal with pension complaints that are brought to us. So the member is bringing them to us, and we're a lot like a court. So we will make a decision on the basis of law. We'll investigate the allegation they make. If we find in their favour, we have the ability to make unlimited awards. We're binding on all the parties, subject only to an appeal to the High Court. So they will, in essence, get the same sort of help that they would if they went to a court. The big difference is, though, that we are free. There's no cost to them. There's no cost risk to them either, unlike the courts. So we're very much levelling the playing fields between them and potentially the better resourced trustee or wrongdoer, whoever it might be. So for scams, we would be doing exactly that. They'd bring their allegation, we'd look at the potential wrongdoer. We would, if we found in their favour, hold the wrongdoer to account. So that would be in the form of a published determination. But in an ideal world, we would be getting some money back for the members as well. So we would look to find liability against the individual trustee, if the trustee was the wrongdoer, and as well as ordering that monies could be paid from the scheme, we could also potentially find personal liability against that individual trustee that would then have to be paid back to the scheme and potentially distributed to the members. So that is essentially what they're getting. They're getting access to the court system, in essence, but for no cost and no risk to them. So we're very different, for example, to the pensions regulator. The regulator is, as the name suggests, a regulator. It's much more reactive. It goes out there. It's looking for problems. It's looking to deal with them. We are a little more reactive because we have to respond to the complaints that are being put to us by those individual members.
Okay, thank you. And the second question, I think, is probably to Anthony. You've made the point, and the institution has made the point, that your Norton determination signalled an important change in your approach. Can you tell us what was significant about it and why you took it on, given that by the time you did, the pensions regulator was on the case and had appointed Dalriada as independent trustee?
Indeed. Well, during that whole period, I was getting increasingly frustrated by the number of members of the public who were cold called, persuaded to transfer from a safe pension arrangement to a completely unsafe pension arrangement with either spurious or extremely risky investments that usually resulted in nothing and them losing their whole life pension savings. And I was completely...
Sorry, you said during this period. What was the period?
Well, the period really started in 2015 when I took over. So it was a long period of time.
It was already happening by that point.
And this was all happening during that period of time. And in fact, I made a decision in a case called Hughes and Royal London, where I refused to allow a transfer. It was a statutory transfer, quite tricky. I used, an area of the law that I well, I knew could be challenged. It was challenged by the company that actually were behind the investment, and they won in the High Court, but it brought about the cold calling legislation. So actually, although I lost in the High Court, I was very pleased that it got a change in legislation, and also ultimately...
Sorry, Anthony, in that particular case, you lost. Did the transfer went ahead, did it?
Transfer went ahead.
Did the
it was a person, just £8,000, and they lost everything.
Right.
Well, maybe in the long term that amazing investment will pay off, I don't know. But as far as I'm concerned, it was extremely risky. And then the transfer regulations, of course, that we have now brought in the earnings stipulation for a company that's set up to have an occupational pension scheme, which was something that I said was missing in that original case. So that was a sort of precursor. Then we had a number of complaints regarding the 3 Norton pension schemes, and we dealt with those initially, because they just came in, just 3 of them. My deputy dealt with 3 of those, and I dealt with the 4th. But when the 4th came in, it was all about transfers. People had asked for transfer from one of the 3 schemes, hadn't been recognised by either Little Dunbar, the administrators, or Mr. Garner, and he didn't respond to those complaints. So I determined that the transfer should go ahead. Nothing happened. We then had a number of other complaints come in, 31 in total. And I decided, having looked, and also I reported it, on the 4th determination, I reported Mr. Garner to the regulator. That was in early 19. And then during that period of early 19, we had a number of other complaints come in, and I decided, actually, we should change our approach. We should take these together, 31 complaints that I had, and deal with them together, looking at the way in which Mr. Garner had taken those monies, used individuals which we subsequently discovered had all been convicted in 2013 of fraud, and transferred the monies into his solely owned company, Norton Motorcycles, through an employer called Manacrest. And that was quite important for me to actually really highlight this issue, because we've dealt with a number of others since then, and this was really the second one, but the first major one. I decided to take down this path.
Thank you very much indeed. Sir Desmond Swain.
And you've just indicated that it was the transfers, the failure to abide by the law in respect of transfers that brought Norton to your attention. But the trustee firm Capital Cranfield reported concerns to the pension regulator in 2013-14. Do you know what it did in response to that then?
I was not privy to that information. I didn't know that they did that.
You found that Garner had assistance in setting up the scheme from Andrew Meeson and Peter Bradley, directors of T12, who were jailed for tax fraud in a separate case in 2013. Do you agree that with the scheme members that and with HMRC that the pension regulator should have picked up on that and prevented the scheme from being registered in the first place?
Again, I'm not privy to the information that they had or what they did about that at the time. Obviously, this is a big proviso because I don't know quite what was going on with the regulator. I knew that they actually were taking action of sorts. I was looking at it purely from a member point of view, so regardless of what the regulator was doing or not doing. I was aware that we were taking some action. With regard to T12 and the tax fraud, obviously in an ideal world, they would have taken action in this case, provided, but I don't know what other pressures or information or resource that they had at the time to deal with it. I just don't know that. So it's very difficult for me to carte blanche say, yes, they should do this, without having that information and the caveats that they would provide.
So what do you, what's your judgment on the impact of the failure to have acted much sooner?
Two aspects. One is obviously, I believe that the monies had disappeared by 2013. But that's not the whole point here. You have got individuals whose lives have been ruined. absolutely ruined. You know, I had so many at my oral hearing that gave evidence. It was heartbreaking, absolutely heartbreaking. And you listen to those cases, and those individuals went through years of stress from the results of what Mr. Garner had done. And when you hear that, and you know that year after year, month after, you put yourself in their position. It's, you know, people had lost their homes. There was a daughter whose father was dying, who tried to get the monies to her daughter, couldn't do it. Another person who couldn't pay, he was trying to use the money for education for his son, couldn't do it. You know, there are so many different cases amongst those 254 people that were members of those schemes that really suffered. So that really is the problem with the delay in dealing with a case such as this.
Thank you. Nigel Mills.
Did you ever consider whether the pension schemes that allowed the transfers into this sham should have allowed those transfers, or whether they could have effectively stopped this from ever happening?
It would have been nice to have seen the transfer regulations coming much earlier. That wasn't the situation at the time. It was quite a straightforward system where someone could register a pension scheme, HMRC. It was tightened up in 2014, but nevertheless not sufficiently in order to prevent these scams happening. And, you know, what amazes me is that a company such as Little Dunbar could set themselves up as administrators, and with Miss Dunbar, when she gave evidence to me at my oral hearing, admitted that she knew nothing about the regulations of pensions. She absolutely was not the person that should be administrating a pension scheme. So that there were definite holes in the whole system and the approach.
In case it helps, we still see a similar sort of issue today, even with the new transfer regulations in place, where there's a tension between people who want to make a transfer and are very much pushing their transferring scheme to do it as quickly as possible, and the need to protect people from themselves to a large extent. So, although I totally agree that there is culpability on some occasions on the transferring scheme, and we found against transferring schemes in the past, both Anthony and I, for not having done sufficient due diligence even before the new transfer regulations came in. There's a balance to be struck between allowing people their statutory right to transfer, quite often to their advantage, and helping them avoid these sort of scams and pitfalls.
Yeah, I mean, I occasionally get constituency cases where you've got a very insistent person that is adamant they want to do something, even though it looks to be a particularly wise thing to do. I suppose at some point it's their money, it's their choice, isn't it? One of the frustrating things, Mr. Arter, I mean, you talk about the length of time it took and the amount that people suffered in that. As I think we heard last week that finally the fraud system has paid some money to the pension trustees to distribute, but that's another few years on from your determination. I mean, do you think there was effectively you found dishonesty here, but that wasn't enough to trigger compensation from the fraud compensation process? That had to wait until the bankruptcy and the liquidation had proceeded far enough, and then they have to do a separate determination of fraud, and the trustees have to ask, and God knows what. I mean, do you think we could get to a better system? Because I think from what you were saying that it was clear to you that by 2013 there was no money, and so you could find all you like against the trustee or against Mr. Garner personally or against his businesses, but that's all for the birds. There was no money to come back, and yet people have had to wait another 5 years to get anything back.
I think it's very sad that people have had to wait so long, there's no doubt about that. And I think the trouble is it's catching up all the time. So if you look at the Fraud Compensation Fund, which when I made the determination in 2020 was just being formed, just being set up, and there wasn't a case really until I think it was June 2020, which was Dariada and the Pension Protection Fund, where in fact it was recognised that defined contribution schemes, it could actually pay monies in such a case such as Norton. So in fact the legislation wasn't there. These things there's always a delay in the process. It's almost as if the accident happens and then we'll deal with it for the future. But of course Norton suffered as a result, and so there was a delay in terms of the whole process. And then of course the way that it works, I don't know if you want to come in on this point, but the way it works at the moment, it's not just a question of the Ombudsman finding a case of dishonesty and that being the trigger for the payment to be made. There are other hoops that they have to go through. I mean, perhaps you want to add?
I not much more. Simplistically, that is right. Our test is not the same as the test that the Full Compensation Fund follows. Perhaps in an ideal world, and we've been exploring it offline over the past year or so, you'd have tests that match together. But I understand from our colleagues at the Full Compensation Fund that that's not the cause of the delay in making payments. To the extent there is a delay, there are the other hoops, like in relevant insolvency events and the need to ensure that money is being claimed from elsewhere before the Full Compensation Fund starts paying out. I think the very nature of processes such as this are that there just are a lot of hurdles to go through, and this was the first one done. I'm sure with the benefit of experience now it will be a lot quicker. Hopefully there'll be far fewer scams though for them to do it.
They still have to go through the insolvency process to see if there are any other monies, of course, before they pay out the monies from that fund, which is obviously taxpayers' money.
No, I think we accept that. I suppose it was apparent pretty early on there was no money here. I mean, what was there? A few £100 left in the pension scheme, and a business with very few assets. I mean, I suppose you have to wait until you're pretty confident. Whether you have to wait several years until you're absolutely confident is a But you're saying so you've had discussions with the Fraud Compensation about whether you could align. I mean, presumably that either means that you align with them or they align with you, or you both meet in the middle. What's the obstacle?
The obstacle, I think theirs is set out in legislation. Ours, we follow our own, the legal system essentially. So I'm sure Anthony can talk about how he did this in Norton. We are making a finding of dishonesty on the civil burden of proof, which potentially, if the evidence is there, allows us to start to sort of pursue the individual trustees for breach of trust. They're just effectively on a statutory regime, the other a sort of general common law regime.
And do the Fraud Compensation Fund need to get to a higher burden of proof?
A different burden of proof. I think it's a strange amalgam of criminal. I mean, they can speak better to it than I can, but it's not the same as ours.
Okay.
But I ought to say they have been willing, with TPR as well, it's the sort of discussions we've been having to try and see how we can make these processes better. I think in general terms, scammers have first mover advantage. They're the ones looking at the system and how they can game it. Unfortunately, the regulatory regime, just as we've been discussing in relation to the transfer regs, are often trying to fill the gaps that the scammers have found afterwards. And that seems to be the case here, where we're trying to, as a group in the pensions firmament, try and fill those holes afterwards.
You mentioned these tensions around these transfer regulations. We did hear last week from Dalriada that they had been appointed to a couple of schemes where the transfers have taken place since the regulations came in. Are there some loopholes in the regulations, or just what are the tensions that you
So
mentioned?
the particular tension I was thinking of is that the first determination I've made in relation to the new transfer regs has not been one where someone has been scanned, but it's a trustee that has very properly identified. It was, I don't want to get into the technicalities, but it was one where the receiving scheme had overseas investments in, and the trustee took a very purist view, the transferring trustee, a very purist view of whether or not that triggered the amber flag that then required the individual to go off and get advice from Money Helper. The member concerned and their IFA were very aggrieved because they thought it delayed the process. It was very unnecessary. It was an entirely reputable scheme that they were transferring to, and claimed that it resulted in loss to the member. So here you had a member say, come on, you've got to get on with it. I'm missing out on investments and so forth. And the trustee very properly has sent them to Money Helper. That is what's happening now. I think it's what you'll see in 2 years or 3 years' time, where people who've made the transfer hasn't had the benefits that they expected, either because of a scam or just general regret risks. Say they've moved out of a DB scheme to a DC scheme. That will be the moment you'll start to see the complaints that actually you should have been sent to Money Helper. And that's where the tension is between people who are desperate to move and get the investment returns that they can see out there, and trustees trying to operate the new transfer regs. And legislation is legislation. There'll always be tension, I think. when it's aligned with the real world.
Okay, thank you. Celine Saxby.
Thank you. Good morning. Anthony, coming to you, and I think you've already touched on some of this, but can you explain why you focused on determining Mr. Garner's personal liability for the loss of the pension scheme assets?
Yeah, I focused on because he was the one that actually had set up this scheme. He was the sole owner of Norton. He was the trustee, and it's a matter of finding that his actions as trustee in making sure that those investments are properly regulated and invested in the right way. He is the individual who I wish to hold to account in terms of this dishonesty finding and his actions.
And did you make any assessment of whether he would realistically be able to pay the amount directed?
We haven't got the ability to work it out. I mean, all hearsay for how much money he's got. At the time that I actually took on the complaints, as far as I was concerned, it wasn't looking at whether he had the monies. It's a question of holding him to account. I wasn't, I didn't have the facility. I don't have the support, if you like, to find out what his assets are. I heard several rumours, such as he owned a safari park, but who knows whether that was true or not. So there were plenty of rumours there, but I wasn't aware of that. All I was focusing on was actually the state that those poor members were in and taking action against Mr. Garner in respect of what he'd done. So for me, that was the priority. Obviously, hopefully, money's at the end of the process, really important. But ultimately, it took me 15 months from start to finish, which actually, given the complication and the process, is actually quite quick for an investigation as with the magnitude of this one, where one has to have an oral hearing to give when you're accusing someone of dishonesty and other aspects, you have to give the individual a chance to defend himself or herself. That's really, really important. And also, going through the evidence and giving a preliminary decision and hearing of the defence to that, it takes that time. But for me, the problem with it, if you like, is it also gives time for the money to be dissipated. That is a risk that when we go through this whole process, at the end of that process, monies aren't there.
Thank you, Chair.
Thank you very much. Did you, I should know this, but I don't, in your work, did you take evidence from Mr. Garner himself?
Mr. Garner was due to attend the oral hearing. He rang one of the team's lawyers the night before. He was unfortunately doorstepped by ITN the night before the hearing, and it was broadcast on the ITN news about the allegations against him. And he rang one of my lawyers to say that he's too frightened to attend the oral hearing because he might be attacked by members. I explained that we had security and he would be perfectly safe. So no, he didn't turn up. And in fact, when I look at the first 3 determinations that were made against Garner, he didn't respond at all. I think he only started to respond when he realised actually the determinations had been made, and it was looking pretty bleak for him.
Debbie Abrams.
Can I just follow up on Celine's question in terms of the personal liabilities and your focus on that? I wonder why you didn't actually look at his business, because he was the sole owner of that business.
Because I was looking at the trust. The company is separate. I'm looking at the responsibilities of the trustee and the pension schemes. So I'm looking at the administrators and the trustee of the scheme, not the company.
Thank you. Very grateful to you there. Could I also go back to your response to Sir Desmond about TPR and so on? I had a sense that you didn't want to criticise them in terms of their action or what they did. So I wondered, rather than say should they have done that, in the ideal world, forgetting the context of their commitments and so on, would you expect the regulator to be able to have prevented the type of scam that they would be aware of?
Absolutely. I don't try and avoid questions. I speak from the heart. the reality of it is, it's very difficult for me if I'm in the place of the regulator and all things being equal and there weren't other issues that I had to deal with that might detract from certain actions. Obviously, ideally, one would take action. I would say with scams, one of the issues with them is they are quite clever, the fraudsters. So they'll set the scam up, people will transfer their monies, and they'll keep in touch with them to say, it'll be a little while before you get a return on this. So people don't tend to complain straight away. So you've already got a delay in that scheme being set up and the person suddenly realising, hang on a minute, this is a scam, my money's gone or whatever, and they start to write. And so there's a process there which, you have to take account of. It won't be instantly when that scam has actually been set up. It's a number of years later. But with regard to this and the information they had, ideally, if there's nothing else, and I don't know, if I were in that position, then, and I had the resources and all the other aspects, obviously, ideally, yes.
Okay. So thinking about the fact that there had been information sent to TPR in 2013, and your investigation started in
March 2020.
There you go. So that's 7 years.
Sorry, March 2019. Sorry, 2019.
So your report was,
my report was June 2020.
So 6 years. That's a long while, isn't it? You'd expect that if somebody had, if information had been provided to the regulator, that they would respond and act on it, and escalate those sort of.
I wish I had all the information for the regulator, but what I would say is they did appoint the independent trustee, which was very helpful to me in May 2019. And that was very useful because that enabled me to actually make my determination in respect of all 254 members, not just the 31, and for monies to be returned to those members. That was really important, and so I was able to bring Derriada in as a complainant, and that made a huge difference. So, if you like, that one act really helped me in terms of the way I responded. But I'm completely separate. I'm looking at it from a member's point of view. So.
Well, there may be more members who knock on your door from other schemes. So I just wanted to explore with you, if that's okay. This was a big case. You said it was the second biggest case of this nature that you had to investigate. So it must have had a huge amount of resources that were taken up. I don't know how large the Ombudsman is.
Very small.
So in that way, so if we're then thinking of what this meant to other investigations that you might be undertaking, it
was a big decision. A big decision to make. I was passionate really about dealing with these cases such as Norton and other cases where people have been scammed. I felt it was a really important area that we should focus on. Perhaps sometimes other things had to give way that were perhaps, in my view at the time, less important. But also, if you think about it, I've had 31 different complaints. If they'd all been investigated separately, that would have taken considerable resource. And also, perhaps they'd have been overlapping and it would have been a complete waste of resource. Therefore, it made sense, not only from the point of view of the Derriada and the 254 members altogether, but also dealing with the separate complaints. And it's a balance between the resource that were required for those and I may have had more complaints. I didn't know if that was going to be the end of 31 complaints. Others might have come in. So it was important to marry that.
Dominic, do you want to?
If it might be helpful to give you an idea of how we think at the moment, and it also comes back to Ms Saxby's point as well, as to whether or not we were looking at whether we could recover any funds during Norton. Obviously I wasn't there at the time, but that is the sort of issue we now have to look at. We are a small organisation, our resources are limited. There are many more cases of this nature that have come in. So at the moment we have 9 cases on foot. We have a further 14 that are paused. The reason they are paused is simply because of resources. So we're having to make pragmatic decisions on which ones are most likely to get justice. So, for example, we will go after cases that set a particular type of precedent. The Ombudsman obviously doesn't set precedent in the same way a court does, but in the case of Norton, that was the first big one. It was setting a precedent to the industry. It was showing what was going on. It was important that we did it, even if monies weren't recovered. Now we're looking more at pragmatic decisions such as which ones are we most likely to get returns for the members on, which ones are we most likely to act as a deterrent on, which ones show a new type of scam or a new way that we can deal with something. So again, not wishing to bore you with technicalities, in most cases with personal liability, the trustees are individual trustees, so it's much easier to get at their own personal assets. Where trustees set themselves up as companies and sit behind the corporate veil as a director, it's much more difficult. So we're looking, for example, at one case...
Don't give them any clues.
No, well, we're looking at that sort of case at the moment to see whether it is possible to pierce the corporate veil. And even if there is no actual recovery there, that would be an important case to deal with those sort of issues, so people don't think that's the right way to go to try and protect the wrongdoer from liability. So we do go through the sort of pragmatic decisions to try and work out which ones are going to bring justice to members, which ones are going to get the most bang for the bucks in the industry. And it's an important thought process to go through.
So does that mean that, first of all, in terms of the criteria that you said, you sort of moved on really about determining then which cases you're going to investigate? Do you publish that? How do you come up with those?
No, it's a case-by-case basis.
Okay. And I understand absolutely your reasoning for looking at them as a group here, but were there any losers then as a result of that? And who were they? Not the individuals, but were there particular? Was it the strength of their?
It was the individual evidence, which was very useful, collectively together, which helped actually me in making that determination. That was very important, rather than looking at each individual claim and what happened to them individually. It was much easier. If we're talking about efficiency and so forth, when we were referring earlier, it is much more efficient then and much stronger from the point of view of my point of view in looking at the case and making my decision, and much less likely for any appeal to the High Court to succeed.
Final question on the the pensions dishonesty unit. I mean, that, given you're a small organisation, that must have been a big, or is a big commitment from you. And does that suggest then that you are expecting to get more and more of these cases, and it's going to take up more and more of your overall resource?
So it's, I ought to say it's not just a commitment from us, it's a commitment from DWP as well. They gave us pilot funding for 2 years, so we're coming into the last year of that pilot funding to help us with those. So we have more flexibility to take on cases, and frankly the 9 cases that are on foot at the moment, we probably wouldn't be doing all of those without that additional funding at the moment. But yeah, we do expect to still see cases. There is a lot of money in pensions. If ever there's an industry that's going to attract scammers and wrongdoers, it is pensions. So although cases of the type that we've seen with Mr. Garner may be a thing in the past, or there may be fewer of them because of things like the transfer regulations, I don't think that they're going to stop trying or finding new loopholes or new ways to try and deal with pension schemes. And I'm still deciding cases, particularly small self-administered schemes. There's quite a lot of investments going wrong there. So I think there is a real need for something similar to the PDU going forward, whether it's the PDU or a more general scams and complex cases unit. And that's something to discuss, but yeah, the need is definitely not going away.
Thank you. Thanks so much.
Thank you. Nigel Mills.
Thank you. I suppose I was just want to go back to a thread I was looking at earlier, but I mean, do you think we've got the regulations in the right place now that we're stopping all of these sort of scams that we can, or do you think there's urgent stuff that we should be trying to tighten up, or is it just a case of we'll have to keep playing catch up, and every time somebody finds a loophole we've not yet thought about, we'll have to... So
I was having a think about this at the exact point before the hearing, which is a good thing too, as the question has been asked. I think the answer is no, for the reasons that Ms. Abraham and I were just discussing, that scammers are attracted to the industry, they're clever, they've got first mover advantage. So I suspect there will always be loopholes, and you will only discover them after the event. From my perspective, the reflection I have is that you need as much flexibility in powers given to the regulator or to the Ombudsman or to people charged with dealing with these issues. A prescriptive, narrow set of regulations doesn't allow for the agility to cater for changes in scammers' behaviour and actions in the future. The more flexibility you give to someone, the easier it is to cater for those changes, and that's where the Ombudsman has a real advantage, because we, rather than using a very prescriptive set of regulations, we're using the flexibility given to us in the law. So Anthony, to his credit, creativity, finding a way to go after them with Norton is an example of that. There are things I think you can do now as well. I think the best way to deal with scams is to stop people coming into the pensions universe in the first place. So having a reputable, and I ought to declare an interest here that my wife is an independent trustee, so I'm not saying it for this reason, but having a reputable independent trustee on every scheme. SASs, for example, used to have pensioner trustees appointed, and then some time ago the requirement for pensioner trustees was removed. I can't remember when, forgive me. But having that sort of independent, reputable body deal with that sort of thing, I think is important. Having professional indemnity insurance covering those trustees to a reasonable level. I've just found against an independent SAS trustee that is likely probably not to survive as a result of what I've done, and I suspect the members who have claims against that SAS trustee will now not be able to recover the monies that they're due. So having PI cover for when things go wrong. Administrators, there is no strict regulatory regime for pure sort of third-party administrators as opposed to scheme administrators under the Taxes Act. Having them covered, so they have to be reputable as well, so you avoid the sort of issues that Anthony was talking about with Norton. So I think it's the entry point and flexibility, to my mind, that are the areas that you can get most bang for your bucks in trying to avoid these scams. And education. That's the other area, probably not for us, but just educating members that, as the regulator is doing, as so many people are doing, that what looks too good to be true is usually, yeah.
It sounds like you think you have enough powers to do, well, you've been in the job a few months, I guess, but you seem to be saying that the way you're set up, the powers you have kind of work. You're not sat here saying, for God's sake, give me this power, I can do a lot more then.
I think our powers are very flexible. Our cases, particularly in this field, are necessarily long. And if you think of us in comparison to the criminal justice system, if someone were arrested by the police would do the work trying to decide whether or not there was wrongdoing. Crown Prosecution Service would decide whether there's a charge. You'd have barristers and solicitors preparing the cases and advocating to a judge, and then a judge making a decision at the end of it. We do all of that. We do the investigation, the preparation, and the final judgment. So we are necessarily long. And because of that necessarily long process, for all the reasons Anthony gave, you will end up with assets disappearing off into the ether. So in an ideal world, you'd be able to freeze both scheme assets and individuals' assets, so that if personal liability was found, there would be assets there to give justice to the members and give them redress. For separation of power reasons, I rather suspect that probably shouldn't lie with us, because we're doing all of those jobs. So the best place for it to lie is with the regulator, and the regulator has those powers at the moment. And certainly over the last year, it's been a completely open door from my perspective. Nausicaa, Erica Carroll, Tony, we've been having lots of discussions how we can make our powers more work better together, be more complementary, so that where there are issues, we can share information, and they can do the things that they can do and rightly should be able to do, and in turn give our determinations more fangs and get the members in a better place when it comes to the end of the process.
So they have the power to freeze scheme assets. Have they got the power to freeze an individual?
So that's obviously a question for them. My understanding, because I've been discussing it with them, is they have something similar to a production order power. And I know Tony's behind me, and you might be speaking to him in a minute, and I hope he's researched this, because I suspect there may be a question on it as a result. But I think they do have abilities to do that sort of thing. Certainly in my discussions with them, it was something they were going away to explore, because you're absolutely right, there's a big difference between assets being in the scheme, which are easy to freeze. You can put an independent trustee in, close the scheme bank account, and then the wrongdoer doesn't have access. But if they've been spirited out or sent to the companies through employer-related investments, they're out of the scheme, and at that moment the wrongdoer gets to do what they want with them and it disappears. That's what we've got to stop.
That's quite a challenge, isn't it? Because in this situation, you'd have basically been stopping Norton from trading, because that would have been the asset you'd have been after. So how you stop a business from buying stock or taking on people or whatever, I think it's kind of those sort of powers that I suppose you could see how it could be used to stop a house being sold or stop a safari park being sold or whatever. But
exactly that, and it's
coming
back to the similar sort of tension we were discussing over the transfer regs. There are people who rightly want to do things with transfers that we shouldn't be stopping. The same is true here. I shouldn't be given an oppressive power to just stop a business from growing.
2 years.
Yeah. So finding that balance is the key thing, and that's where flexibility and checks and balances and oversight come in.
Impartiality is really important to remember. We have to be very, very careful in how we react to these cases until we have proper evidence.
Okay.
Thank you. Looking back on the work you've done on Norton and the other cases, and you've told us you've dealt with quite a number, how exceptional is the Norton case?
Norton was exceptional. There was another case, Dawson, just prior to Norton, where 54 members, the Henry Dawson pension scheme, Mr. and Mrs. Dawson set the pension scheme up and had 54 members, 2.4 million gone. Again, spurious investments. And that was really the very first case where I decided, so it was just prior to Norton, where I decided to hold this collective process and hold Mr. and Mrs. Davison responsible for the loss of monies, personally liable. That was the first case. Norton was the second one, but Norton was far, far bigger, much more important in terms of the number of people it affected. The Davison case really had a lot of people who were semi-professional investors, or they like to think of themselves, not all of them, but some of them, whereas, of course, Norton, these were perfectly innocent members of the public who have been persuaded by people who ultimately were convicted to transfer their very safe pension arrangements in various schemes into Norton. Some were motorcycle enthusiasts, they liked the idea of it, and of course they were persuaded on that basis. For me, it was really the catalyst for setting up the dishonesty unit. From that point on, the result when in June 2020, when I made my determination, I kept DWP informed all the time, and DWP and the Minister supported the monies we needed to continue dealing with these scams, of which there have been, a number since. There was one last Christmas, 13.5 million. And without that resource, without that money to be able to deal with those cases, we couldn't have continued dealing with them in that way, because obviously, as you quite rightly pointed out, the resource is considerable in looking at that case. And when I started that, we were only about 60 people. We're not hundreds of people, and we've got other complaints coming all the time that have to be addressed. So it is a question of priorities, but we did have the monies to set up that separate unit, which for me was really, really important, because scams at that time, and they were still coming through, were just, it needed someone to represent the individuals who were complaining, and to let them have their day, actually explaining what had happened to them. That's a really important part of that process. Rather than bits of paper going backwards and forwards and they're just getting notes from different organisations, etc. Actually, their day when they can explain exactly how they feel is really, for me, is really important.
Just to give you a couple of figures, if that would help, Chair. Yeah. So we have 12 months, or just over 12 months, until the PDU pilot comes to an end. Over those 12 months, we have £31 million worth of funds at risk of the investigations that we're focusing on. More importantly, that's 600 members that are affected. So even if you say there's only 2 schemes or 2 scams, you've got to look at it the other way as well from a member perspective. That's 600 members that are having their lives absolutely ruined. And those are just the ones we're dealing over the next 6 months. There will still be legacy ones that come through. There'll still be different scams. So things like Norton, yes, big ticket, unusual. There are still plenty more.
Do you know how many schemes you've dealt with over the 10 years?
I wouldn't know. I can come back to you on that if that would be helpful.
Might be useful to know. But from what you're saying, Norton was exceptional because of the size of it, the number of victims. I mean, have there been others of a comparable scale that you've looked at?
Optimum was a big with 13.5 million was taken.
What was the name there?
Optimum. So that's a big case, and it's very interesting. The individuals involved in some of these cases, some of them are very intelligent. We've had chess grandmasters involved with scams. We're not talking about, your local criminal who might suddenly get involved. Some of these individuals are quite clever, and they really work out how they can actually extract these monies and how they can get rid of the monies very quickly through different companies and organisations.
The chess grandmaster was involved. Which scam was that person involved in?
I'm sorry?
Which scam was the chess grandmaster involved in?
Focus. Was it Focus? I think Focus. It was. Can I come back to you on it? I think it's a Focus scheme, but I'll confirm that with you.
Actually, the fact that you determined there was dishonesty in the Norton case has proved very important, because it's opened the possibility of a successful application now to the Fraud Compensation Fund. The judge who dealt with the prosecution by the pensions regulator of Mr. Garner said that if the pensions regulator had said there was dishonesty, then Mr. Garner would have gone to prison. Do you think, Mr. Garner, you've spoken to him from what you said to us earlier, do you think he should be in prison?
I personally would like to see him in prison, but that's a personal thing. The point about it is, of course, it is on a different standard of proof. So for us, it's a civil standard of proof, the balance of probability, and that's the standard that I judged. Looking at the evidence, I came to the conclusion that Mr. Garner had been dishonest on the balance of probability. Of course, a criminal prosecution depends on the offence being prosecuted, and then it is a question of proving the matter beyond reasonable doubt. So it is a, if you like, a question for the prosecutors to decide, on balance, will they achieve, the jury or the magistrate or wherever the court is, to find that this was definitely beyond reasonable doubt. And there's no doubt that Mr. Garner put all sorts of defences in place. So the question is whether a jury or the magistrate might take into account, he was very naive, he was taken in by, Mr. Bradley, one of those convicted in 2013, his brother was a solicitor with Bradley and Jeffries, that's Matthew Bradley. Matthew Bradley was Mr. Garner's personal commercial solicitor. Quite interesting connections all through there. So you could see that he might throw a defence that he was just taken in by these individuals and was completely innocent, didn't understand pensions. Well, of course, he shouldn't have become a trustee, didn't understand, but that's beside the point. When you're looking at a criminal prosecution, it might be more tricky than it would be for me to actually look at that evidence, look at the standard of proof required on the balance of probability and find that he's dishonest. So it's a tricky one, but I would have personally, of course, liked to have seen him prosecuted and imprisoned for the offences. All those people have suffered so much.
Thank you. Dominic, can I just ask about how things are at the moment? How long is complaint assessment and then adjudication taking at the moment?
Too long, I think, is the short answer to that. It needs to improve, and we're taking...
Can you tell us what the average is?
Yeah, absolutely. And if I do it in very simple terms, if a complaint comes in, there are essentially two routes you can follow. One is an informal route to our resolution team, where we essentially try and mediate and have both parties accept whatever the outcome may be, make a payment one way or the other. The wait time there is currently 11 months for one of our resolution team members. If it follows the more formal route, where the investigation, so we talked about the sort of criminal justice analogy, the investigation process, that's necessarily longer. You first go through an assessment process where we look to see whether it's within our jurisdiction, does it hit the time limits, all those sort of things. At the moment, the waiting time for that stage is around 12 months. if you go through that, and this then becomes cumulative, you then go into our adjudication queue for the investigation and potentially a determination by me or Anthony as DPO, and the waiting time for that is 12 to 15 months, so much too long. Can be shorter if it's a less complex case, can be longer depending on specific issues. So to give you one example, there's quite a tranche of overpayment cases where members have been overpaid, the scheme is trying to recover it. A number of those cases got stuck behind a Court of Appeal decision that we got last November, awaiting that, so you can get stuck behind those sort of things. But it's too long. When I sat in front of you before my appointment last year, I talked about evolution, not revolution. Now, being on the inside, there's no more talk about evolution. We need to, and we are getting a grip on these things and are going to sort them out.
So it is coming down, is it? The weights?
Depends how you look at things. Annual report and accounts came out and it was coming down. For the first time in many, many years, we resolved more cases than we received. So on that basis, it was coming down. Unfortunately, we suffered a bit of an IT cyber issue last year, and that has resulted in our IT systems being closed for a little while and then being less efficient than we should be. So I suspect those inroads would have been regrettably not continued this year. If it helps, I can talk through what we're doing about it.
Well, I suppose the question in my mind is whether you've got the resources to reduce the weights to an acceptable level, over the next couple of years. How do the prospects look?
And if you start from first principles, what's the cause of the waiting times? I think it's really a function of supply and demand is going up and keeps going up. So on average, it's around sort of 10 to 12%. We predicted 12% for the last annual report and accounts, and it ended up being 17% increases in demand. We are a popular service, as befits a very complicated area. So around 5,500 complaints in 2020-2021, up 30% to 7,200 in 22-23. So it just gives you an idea of just how much things are going up. On the supply side, funding hasn't kept up with demand. Our funding comes from the General Pensions Levy. We're very grateful for some temporary increases that have been granted to us by DWP. We obviously work very closely with them and they have been helping us where possible. But ultimately, those temporary increases aren't enough to both deal with the increases and the historical backlog, because those are the two issues. Every year we get the temporary increase, it effectively keeps our head above water for the increase in demand, but does nothing to erode that historical backlog. And of course, temporary increases also cause us an issue with recruiting people and training them up to deal with what is a frankly pretty complicated area. Having said all of that, we need to grapple with the levers that we have as well, because it's not just about funding. To my mind, there are effectively three levers you can pull as an ombudsman. The first is funding, which is a hard one for me to pull because it's not strictly in my gift. But we have, I hope, election depending, a spending review due this year, and that's our chance to reset our baseline funding. We also have a public bodies review that was delayed from last year, and we would very much like to discuss the prospect of some sort of demand-led funding model, similar to that which the Financial Ombudsman Service has, so that when we have unexpected increases in demand, we can sort of flex with it, rather than be perpetually in this discussion over what happened last year and what we need this year, which then gets overtaken by increases in demand the following year as well. The two levers that I really can pull are on this, first of all, supply side, making us a much more efficient organisation. So towards the second half of last year, we commissioned an operating model review, and that's at the end of this month, beginning of next month. We're going to finalise that, present it to our friends at DWP, and hopefully then start to move into an implementation phase as well. So we're looking at earlier closures, fewer handovers, all the things you'd expect us to be looking at. And just to give you one example, we'd like to be much more like a court. A court can deal with cases through summary judgment at a very, very early stage. I shouldn't be looking at things as a determination that have been in our queue for 3 years that are very simple cases. There must be a way of disposing of that more quickly. But at the moment, the legislation says that every member has a right to take it through to determination. At the moment, we can't even put them through without their consent into our resolution team. And our resolution team is really successful. They close 80% of the cases they receive and resolve them at that stage. So we need to be able to send the appropriate cases, because we're here to help the individuals, through to resolution to get those resolved early. We've got to be able to close through similar things to summary judgment cases earlier, and that will mean that we're concentrating and dealing with only the most complicated cases like Norton that need those sort of, I don't know whether you've had the pleasure of reading Norton, but it's 100 odd pages. If we did that for every single determination, we'll just grind to a halt. So we've got to be much more pragmatic. So we're looking at lots of those things, how you triage things when they come in. The other lever that I can pull is surprisingly on the demand side. So plucking lead cases out before they get to us. And to give you one example of this, and you might have seen in the news that lots of members of the Boots pension scheme are aggrieved at what's happened as their scheme has moved to buy-in, and I think there are quite a few hundred of them moving through dispute resolution. So what I suggest doing in that sort of situation is reaching out to both the union sponsoring it and the trustees of the scheme and trying to find an example lead case that we could accelerate, determine quickly. And if you do that, it sets the principle that the trustees can then say, actually, we lost. We better, during dispute resolution before it gets to us, mea culpa, we did it wrong, and it stops it getting through to us. Or equally, if we find for the trustees, hopefully the members can then see, actually, there's no point in bringing it through. So if we set that precedent and we stop stuff coming through the door, we try and shape the industry. We go out there and say how people should be dealing with overpayment cases, trying to make sure that members exhaust dispute resolution before it gets to us. So just stopping that stuff coming through the door. So those are the two levers we're really concentrating on at the moment.
Can I finally raise with you a different case that we haven't mentioned so far today? This is the AEA Technology case, the commercial subsidiary of the old Atomic Energy Authority. Do you agree that members of that scheme haven't yet had an adequate appeal opportunity?
I think everyone should have an appeal opportunity, but only within the law. So one of the points worth remembering here is that we are sort of an independent ombudsman bound by law. Yep. So I haven't had any of these come across my desk, so Anthony has. But as I understand it, in that particular case, they're blocked by a number of issues with us. The first being that they're out of time, so we can't give a remedy that the court can't give. And in cases such as this, there's a 15-year long stop and a limitation act that would prevent me from looking at these sort of issues. Secondly, our jurisdiction is limited, and I gather in this particular case they were particularly aggrieved with the Government Actuary Department, and it's not clear to me, even after the changes made in 2004, 2005, whenever it was, to our jurisdiction, that GAD would fall within our jurisdiction. And secondly, we are independent and we'd need to then go off and actually decide whether or not they had a case. In principle, yes, I do agree. Everyone should have an opportunity to find access to justice.
And do you think you're the right body to provide that opportunity?
It depends who it's against. So if it was against the trustee, I think they're the right body. It's a technical pensions issue, so again, we're the ones with technical pensions expertise. Equally, GAD are a government agency, so PHSO might be an appropriate port of call for them. I think that's a matter for gentlemen and ladies in this place to think about. But I will deal with whatever cases are put in front of me within my jurisdiction, and I'll decide them independently as my office.
Do you think this example points to some expansion of your jurisdiction that's needed, or you're not seeking?
Either us or PHSO. I think to the extent there's a gap and there's not access to ombudsman justice. So I know this is a sort of nice segue back to what I said at the beginning. The value that ombudsmen add to the world of consumers and the man on the street is that we're giving access to justice without cost or cost risk. To the extent that you have a group of individuals whose only course of action is to go to the courts with all the pain and cost that entails, then yeah, absolutely, someone needs to do it. I'll be happy to, because it's technical pensions, and I enjoy technical pensions, and that's our value add. But equally, I could see an argument for PHSO as well.
Fine. Well, can I thank you both very much indeed for
Thank you for your time.
set of answers to our questions. Order.
The proceeding is currently suspended. 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 The proceeding is currently suspended.
Order, and welcome everybody to this meeting of the Working Pensions Select Committee. Welcome to our second panel this morning, giving us evidence in our inquiry on the Norton pension schemes and the Fraud Compensation Fund. Can I ask each of the four members of this panel to tell us very briefly who you are, starting with David Taylor.
Thank you. I'm David Taylor. I'm Executive Director and General Counsel at the Pension Protection Fund, which oversees the Fraud Compensation Fund.
Thank you. Sara Protheroe.
Good morning. I'm Sara Protheroe, Chief Customer Officer of the Pension Protection Fund and responsible for the operational management of the Fraud Compensation Fund.
Thank you. Maria Evgenidou-Wright.
Hello, I'm Maria Evgenidou-Wright. I've been with the Pensions Regulator for over 20 years in a variety of roles. For the past 5 years, I've been head of enforcement, and in that capacity, I had oversight of the Norton case from 2020 onwards.
Thank you. And Tony Raymond.
Yes, I'm Tony Raymond. I'm General Counsel and Director of Governance Risk and Insurance at TPR. I've been at TPR for 16 years. I've also had a variety of different roles at TPR whilst I've been there.
Thank you all for joining us. So can I then put the first question to the TPR witnesses? So in October 2011, your determinations panel suspended Tudor Capital Management from acting as trustees, and its directors, Andrew Meeson, Peter Bradley, having by then been charged with tax fraud. So why did you nevertheless register the Norton schemes in 2012?
So I think just by way of context, first of all, over that period between 2010 and 2013, TPR had a very high volume of scams and liberation, as we called them then, type cases. And at that point, we were focusing our resources on disrupting those models as we saw them arise. So at that stage, as you say, we suspended Tudor Capital Management. That was as a consequence of receiving information from HMRC that they were arresting Bradley and Meeson in relation to pensions tax matters. We then also took action in relation to a number of related schemes to Tudor Capital Management Limited, TCML and T12. It is obviously fair to say that TPR received a whistleblowing report in 2013 relating to Norton. We referred that to action fraud. We didn't prioritise that case because of the other cases, many of which had even more egregious features than the Norton case, and that's not to diminish the importance of Norton. And those were cases where members were receiving, for example, reciprocal loans from other schemes, where there are intercompany loans between different entities, and models where there were attempts to try and generate a surplus and extract that surplus to liberate them back to the pension scheme members. So at that stage, it was a prioritisation decision.
But, I mean, so you registered the Norton schemes in 2012, despite the fact that Tudor Capital Management had been suspended. Was that because you weren't checking thoroughly enough at that stage, or what? I mean, I take the point that there was a lot going on at the time, but looking back on it, given the information that you had at that stage, would you now say you shouldn't have authorised it, or was there other criteria that meant that it was appropriate to authorise it?
So at that stage, the first, in terms of registration, just to paint the picture back at that period of time, the scheme would have to register first with HMRC, and then they would register at TPR if they had 2 or more members as an occupational pension scheme. That registration process isn't an authorisation process in any way, shape or form. It's simply that information being put on our register. So it isn't, at that point, there wasn't any checks in the way that you've described as far as I was aware. I know that HMRC tightened up those registration provisions in 2013 and 2014 because it was seen that actually the ease with which registration could take place was a key enabler for scam activity. So there was then an introduction of different checks that enabled HMRC to challenge whether there was concerns around having a scam, and they had powers as well to deregister and to impose penalties. And then in 2014 they had checks that enabled an assessment of fitness and propriety on the part of the scheme administrator. So it really tightened up that framework, and it actually led to about an 80% reduction in registrations at that time.
So the reason that you did register the Norton schemes was because you didn't check at that point?
So it's difficult for me to answer that question because there are a lot of the records that I've not really been able to sort of access to answer definitively. So that would be my best view.
Right. I mean, we've certainly heard that HMRC wasn't making checks. You just sort of fill in a form and they issue the registration. And from what you've said, it was the same at the Pensions Regulator.
I believe so.
Right. How has it changed now? What are the checks that you make now before registering a scheme?
I think there have been a number of changes to the framework generally. Obviously, the committee has heard for this today and last week in relation to the flagging system, which you're aware of. But there are also checks in relation to, from HMRC's perspective, that the employer is a going concern. So it's not just a shell entity. And there's also been a ban around cold calling as well in 2019. So all of those mechanisms have been quite important in hardening up the framework insofar as scams generally.
And are you able to shed any light on why there weren't any checks, 10, 12 years ago? I mean, it's easy to say now, but were there any particular reasons why there weren't checks?
I have to say I don't know is the honest answer. Although I worked at the regulator at that time, the reasons. I mean, to an extent, the framework provides the information is provided to TPR by way of registration. It isn't a mechanism to actually check all the elements of the scheme once that information is provided to us, and that was obviously the case as well for HMRC, who registered in the first place, but then that was then changed, and I think that was a very helpful change in terms of disrupting this type of activity.
Nigel Mills, yeah.
I didn't hear you express any regret or apology for the fact that the whistleblowing referral wasn't followed up on. I mean, do you with hindsight, think that was the wrong decision, and you kind of wish that you had managed to take some action a decade ago that could have saved some people some pretty miserable times?
I mean, it's fair to say that obviously the impact that this case has had on the individuals of this scheme has been utterly devastating. Regulator does absolutely everything it can in this space. It's not just this case, but a large number of cases where members have had a similar devastating impact. If we could turn the clock back and do it differently, yes, simple answer. And to that extent, obviously, I apologise. There are good reasons for why things have happened as they have. I've talked about the prioritisation that we had to do back at that point. I have some personal recollection of that because over the period 2010 to 2013 I was a litigation lawyer who was involved in a lot of those cases, and those other cases that I mentioned earlier on were particularly egregious, and they had investment models that were obviously shams, and there were reciprocal arrangements to loan pension members the money, which was obviously liberation, and those were the cases that we particularly focused on to disrupt. And over that period of time, it also became clear the importance of educating the market, and we've done an awful lot of work in that space, as well as seeking to disrupt this before it happens, because the truth of the matter is that once these models are established, it's sometimes too late, and the key is to disrupt it before that happens by way of taking down websites, for example, if people are seeking to advertise this type of activity.
Did you have any realistic expectation that referring it to action fraud wasn't much the same as sticking it in the wheelie bin outside your office? And did you ever get any feedback from action fraud that anything ever happened?
I'm not aware that we did, but that wasn't necessarily unusual. I mean, at the time, the best view was that that was the appropriate mechanism, the appropriate portal. I know the committee some years ago asked questions about about action fraud, and I know quite a lot of improvements have been made in relation to how that mechanism operates.
Just finally, you said you hadn't been able to access certain records. I mean, we're trying to establish what happened here. You're appealing before a parliamentary committee. Is that not able because the records aren't available, or because somehow IT mean you can't get at them, or did you just try and
so some records have been destroyed because of our retention period time frame, so that's the simple answer.
Really, in relation to a case that's been going through various courts and fraud processes still ongoing, you've destroyed records?
Well, we've got the records obviously in relation to this case, and so we received a whistleblowing report in March 2013. Obviously I can help the committee with that. The question I was answering in relation to records was in relation to what did we do around registrations back then, was my, just to clarify the answer to that question.
We heard from the Pensions Ombudsman that they kind of identified a need for change in the law. Was TPR aware of that as well? Did you ask DWP to make any changes in the law? So
over that period of time we were talking to colleagues in DWP as well as other organisations as well, and there, some of the changes I've talked about I think were in some measure to do with the discussions that TPR were having as well. So cold calling, for example, was an important change, and the ban in relation to cold calling made a huge difference. And that was a lot to do with our work with Project Bloom, which is now the Pension Scams Action Group. So I think those things did make a difference to hardening up the framework.
Were there other things you were pressing for at the time?
So I've mentioned the registration of schemes, which is a matter for HMRC. I think what else would I mention? Obviously flagging, which the committee's already heard about, was also another important disruptor, and I think it's made a big difference in terms of reducing the number of this type of transaction.
The changes that were eventually made on transfers, did you identify the need for restrictions there or constraints on transfers?
Yes, I mean, that is one of the key points in the story. Once the checks that take place around the transfer, and obviously having the flagging system which provides for, unless it's a transfer to a collective defined contribution master trust or public sector scheme, then there needs to be some employment relationship with the receiving scheme, I think has been really important. I know DWP commissioned a review last year which looked at data from December 21 to February 23, and I think they extrapolated about 2,000 transfers were disrupted as a consequence of that flagging.
Yeah. I mean, my question really was, if we go back 10 years to when the transfer that we're focusing on occurred, were you identifying at that point that there was a problem with transfers, that something ought to be done about?
To my best of my knowledge, yes. But I mean, I think we also were focusing on education and liaising with law enforcement to get an enhanced intelligence picture.
But having identified the need, did you raise that with DWP?
I have to confess, I don't know.
I mean, if you were able to come back to us,
yes, of course.
Let us know. That would certainly be of interest. Thank you. Sir Desmond's fine.
Thank you. Dalrida told us that it was appointed to two schemes earlier in 2023, which were, and I quote, active and to which legitimate schemes have made transfers after the 2021 regulations were put in place, which suggests the 2021 regulations are not being as rigorously applied as they ought to be. Discuss.
So this is a slightly difficult question for us to answer because it is a live investigation. So there is a limit to what we're in a position to say in relation to it. I think it's perhaps the exception.
Perhaps in the general, are the regulations being sufficiently enforced?
I mean, I'd probably just reiterate the point I made in relation to DWP's analysis of the number of transfers that have been disrupted as a consequence of those new flagging regulations. Obviously, we can write to the committee when it's a less sensitive issue in relation to that particular case, but we don't want to prejudice what's going on. But I think, on the whole, we are satisfied those flagging systems are very, very helpful. Would it eliminate all types of this activity? Probably not, for the simple reason that scammers will try and find gaps in the system. So being on our mettle to engage with law enforcement in this space and to put this issue at the top of the national fraud agenda is really important, and that's something we've been working really hard to do with the National Economic Crime Centre and producing threat assessments last year with the National Fraud Investigation Bureau as well. So those things are really important, and we continually need to re-examine that framework to ensure that we're disrupting this activity.
Thank you. Nigel Mills.
Just to follow up on where we were before, the TPR was clearly aware that T12 were not, let me put this generously, not the most competent or reliable of a scheme trustees, given you were appointing independent trustees to replace them, I think, over a 3-year period between 2011 and 2014. It just seems a bit of a surprise that when you got a whistleblower refer another scheme that they were involved with, you didn't think, oh God, it's them again, we best do something. But that was just the same prioritisation, was it?
I mean, looking at the situation now, it obviously feels uncomfortable. I can't get around that, and this case has gone on for a while. But I can recall at the time we had a very high volume of cases which were even more egregious than the one this committee is looking at today. And those were the cases we had to allocate our scarce resources to address by way of trustee appointment and so on. So I recognise the issue that and the point you're making.
Perhaps if I could just come on specifically for the Norton schemes. So T12 were the administrator for these schemes, And as you rightly pointed out, we had concerns about the administrator. Obviously, they were not the trustee, and in fact, Mr. Gunner replaced them as administrator very shortly after with another company.
This was quite egregious, though, was it? I mean, we had some criminal administrators, we had a unqualified trustee moving money out of a pension into his own business over a decent period of time. I mean, this was there's a whole collection of stuff here that was completely against any kind of sensible observation of the rules, wasn't there? But I suppose that's 10 years ago. So you did finally launch an investigation in 2018. It took until May 2019 to appoint Dalriada as independent trustee. Do you know why it took quite so long?
Yeah, so we in fact launched an investigation in 2017, so we received another whistleblower report in 2017. But initially we carried quite limited inquiries. That was because there was a police investigation ongoing with South Wales Police, and they asked us to limit our investigation whilst they were prosecuting an individual called Simon Colfer, who was what's called an introducer to the Norton schemes, and Mr. Garner was a witness for the prosecution in that case. So we had some limited inquiries in 2017, but from 2018 we expanded our investigation, and that's when we contacted Mr. Garner directly. The reason it took another year or so before we appointed a trustee using our powers was that Mr. Garner was cooperating. He admitted himself that he wasn't a competent trustee, that he wasn't able to take care of the schemes, and he was going to appoint voluntarily an independent trustee. And he in fact had spoken to a number of trustees, I think including Dalriada, and it looked like he was taking the right steps to make the appointment himself. However, after it became apparent that he was being very slow and there was not enough progress with the appointment, we then started the process to formally use our powers. The process does take some time. We have to follow due procedure. We have to go out to the various trustee companies on our register and ask them to tender for the appointment. And then we have to follow what's called the case team procedure. We have to go out to everyone who's affected to allow them to put their representations in before we go to our independent determinations panel, and they make the decision to appoint the trustee.
And was the request from South Wales Police something you think was reasonable? I mean, is that common? I mean, it's a bit like saying, would you mind not stopping these pension scheme members from being robbed a bit more because we're doing this case and it might hurt our case? I mean, it's a slightly sort of strange thing for you to decide not to exercise your powers on something that wasn't really related to that case, was it?
We would have established that by that point that there was no immediate risk to scheme assets dissipating, as I think the committee has...
Because they'd been dissipated already.
The money had already gone into Norton by that point, so if we had just there was an immediate risk, we would of course have used our powers immediately.
But we heard in the previous panel that you have power not only to freeze pension scheme assets, but may have it to freeze individual assets. So at that point you're saying we knew that the money had been taken by Mr. Garner completely contrary to what regulations allow. You weren't tempted to use those powers to try and freeze the assets at that point?
So TPR does have powers where scheme assets have been misused and misappropriated to go to the High Court for injunctive relief. I think that there is an assessment there as to the immediacy of the risk of those assets being dissipated in circumstances where there is a trustee appointed, the point at which the trustee in this instance was appointed, the title to those assets vested with that trustee. So at that point there is a protection, if you will, in terms of the immediate risk. So there wouldn't be a need for us to go off to the High Court at that point.
I'm just slightly intrigued that you say you didn't need to do anything in relation to the pension scheme in 2017 because you knew the assets had already been transferred into Mr. Garner's own name or in his solely owned businesses, but you didn't think, well, let's go and use the powers we have to go and stop those assets being further dissipated. I mean, that seems...
It's often the case in instances where TPR appoints a trustee, that the trustee takes on that mantle. And indeed, in previous cases...
But this was 2 years before you appointed a trustee.
Yes, but sorry, I was speaking sort of generically, that where we appoint a trustee in circumstances where there is a concern, they will often take on the mantle to try and protect the assets, and sometimes go to the High Court themselves. I mean, in this particular instance, obviously we took various decisions, and as my colleague was saying, at that stage the money had already been invested in the preference shares the committee is aware of.
I'm just intrigued that you got as far as knowing that, but you didn't think that's completely contrary to what's allowed. Shouldn't we step in and try and stop that money being further dissipated at that?
So I think in this case, obviously the way the investments were made was illegal, and as it turned out, the investments themselves were inappropriate and ended up not being worth anything. However, we don't have powers to get the assets back from an investment that has been made, that is a valid investment, a legal investment.
Okay, I'm just intrigued about how you appoint independent trustees and the kind of deal they get, because I think what we heard last week was they only get paid if there's any assets at the end. So if there wasn't effectively a successful claim on the fraud compensation fund, then Dalriada wouldn't have got paid at all for this. I mean, is that a sensible way of remunerating independent trustees? Because either it's a very risky business that I get myself into that isn't very attractive and I might prefer to go and do other stuff, or I'm going to set my charge out rates such that if I only get paid in 1 in 3, I'm still making a profit, so I'll be charging a very high amount to these schemes I get landed with. I mean, does this feel like a fair and sensible structure?
I mean, the fact that it is now the position the Fraud Compensation Fund can pay schemes after a certain point is very helpful, but your point is a fair one in terms of the difficulty that we've got in circumstances where the scheme has insufficient assets to pay an appointed trustee, and the company to whom the scheme is linked is a shell entity. And that certainly was a difficulty that we encountered from the beginning. Could there be some kind of legislative alteration to assist? I think so. That you could have some kind of publicly funded trustee in that instance, but it has been enormously helpful that the Fraud Compensation Fund can now pay where they have received an application.
Just to add, I think it's fair to say that prior to the court ruling that clarified that these schemes are eligible for compensation, there were a number of schemes that we were not able to make appointments for the reason that there were no assets in the scheme or the employer, so they weren't commercially attractive to any of the firms on our register, which is why there is now a backlog of schemes that we are now looking to appoint now that we've got the compensation route.
Do you recognise the point I asked about the risk is that costs get inflated because there's so much risk that I may not get anything back, that I've got to do it on a portfolio basis effectively, and that effectively the risk is that scheme members end up getting clobbered for more than was probably needed to?
I'm sure colleagues from PPF will talk to this. I mean, to the extent that the fees relate to the dishonesty, then those are recoverable. We have a process when we appoint trustees on our register, have to be fit and proper and have the requisite experience. We go through a tender exercise when we appoint trustees. We check the fees against those tender that tender exercise originally. So there are checks and balances there.
But do those tenders show hourly rates higher than you would generally see quoted to administer a normal trustee situation?
I can take that. So I think it's fair to say that these types of appointments require different skills to a normal trustee appointment and specialist skills, and that there's very few trustee firms that have the capability to do these appointments, and yes, the rates would be different. It's different kind of work.
But we do, as we say, get to the happy situation of the Fraud Compensation Fund, I think, seem to be picking up 95% of the cost on this scheme. I think we heard last week. I mean, it seems slightly generous that they get paid 95% of their costs and the scheme members get not very much back of what they really lost. But are you happy with that effectively being how the system works?
Step in on that. I mean, the costs when we thanks to the case in 2020, it's clear that the Fraud Compensation Fund can pay those costs, and so those costs won't be to the detriment of the members. We will pay the hole in the pension scheme caused by the fraud and those extra costs to pursue the claims and so on. The 5% that I think Dariada were talking about last week, I think, is the ongoing costs of the normal scheme, and I guess just to pick up on the earlier point, there are a number of things that have happened since that court case that does make it easier to get the independent trustees in. First of all, the fact that we know that their costs will be paid ultimately. Also, we're able to give an earlier indication of whether we think the case is a runner or not through the indication of the dishonesty test that I'm sure we'll talk about later. And also, DWP helpfully changed the regulations so that we can make payments as we go along, so they don't have to wait for all their cash until the end. I suspect Sara might want to say something about how we keep control of trustee fees as well.
Would you like me to take that now? So we are dealing with the regulator's agreed rates for this work, so we're working within their framework. But we ask trustees always to seek permission from us before they undertake any legal action, pursue legal fees. We want to understand that, and as we're developing our own expertise, we find that is less and less necessary. We're actually able to deal with much of that ourselves. Similarly, when trustees are considering pursuing recoveries activity, which can be extremely costly, we get involved to advise on whether or not we think that is a sensible use of funds. So we seek to control the costs as far as we can as we move forward. And of that recent payment to the Norton scheme, for example, of £9.5 million, about 10% of that represents third-party costs, and 90% will be for the benefit of the scheme and therefore ultimately the members.
Do you constrain how much money the trustee can spend communicating with scheme members? I mean, I think Dariada did suggest that they had to balance giving members the communication that some members seem to have wanted with how much it costs to do that.
No, we don't impose constraints in that area. Clearly, the Fraud Compensation Fund monies come from members of other occupational pension schemes, and so we have to have regard to both the members who will stand to benefit from the Fraud Compensation Fund, but also those members who stand behind the levy. But in terms of communications, we absolutely understand that members need to be kept well informed. We look at all communications that reference the Fraud Compensation Fund, and we work with trustees, for example, on documents for them to send out to find out about monies that members have received already. So we're closely involved in communications and support communication activity with members.
Thank you. Then, Ms. Evgenidou-Wright and Mr. Raymond, I mean, I think Dariada told us last week there needs to be clearer reporting channels for schemes and advisors to flag concerns and allow for a better flow of intelligence to TPR. Do you agree that these reporting channels need to be improved, or do you think they were?
It's something we updated last year. So we've updated our web page in relation to the reporting. So there are a lot clearer signposts now as to where a trustee would need to report. We continue as well to promote our pledge campaign. So committee, I think, may have heard about this a few years ago. So this is a campaign which we're supporting with the Pension Schemes Action Industry Group, and their code of practice, and getting schemes to sign up to that pledge. And that code of practice includes a large compendium of documents to support trustees to what to do in this type of situation, so templates and risk assessments and so on. And so we've had 640 schemes sign up to that pledge, and we particularly focus on the master trust area, so there's 70% of the master trusts have also signed up to that pledge as well.
Okay. Thank you very much. Sir Desmond Swain.
Thank you. The Pensions Ombudsman found that Mr Garnier had committed multiple dishonest breaches of trust and maladministration. How do you justify to scheme members that you didn't pursue him for dishonesty in your prosecution?
So the simple answer to your question is that we're led by the evidence, and we took the case where we considered to be the most likelihood of conviction. But I'll pass over to my colleague Maria to talk a bit more about that.
Thank you. So yes, TPR does prosecute for a variety of offences. Some of it is in pensions legislation, but we do also pursue fraud prosecutions, and we've had a number of successful convictions in that area. But of course, we have to focus our resources in the cases where we think we've got the best case for a successful conviction. In this particular case, we investigated, and based on the evidence, we made the decision to pursue Mr. Garner for pensions legislation-related offences. I was personally involved at that time, and I can assure the committee that we weighed the evidence very carefully and looked at all the information we had before making this decision. And ultimately, we determined that we had the best chance by going for the employer-related investment offences. And we stand by our decision. We think it was the right thing to do in the circumstances, as was shown by the fact that we got a swift conviction in the case, and Mr. Garner received suspended sentence, prison sentence. He was also disqualified from being a director and ordered to pay costs.
Am I wrong in my understanding that one can pursue a miscreant on a number of charges? Even if you are unsuccessful in sustaining a charge of dishonesty, you could still get him on the other chances. What is so galling to members of the scheme is that their perception of the dishonesty, and indeed it was detected by the Ombudsman, was obvious, and it's a matter of incredulity that it wasn't pursued. Even on the basis that you might not have been able to sustain it, you'd have still got him on the other charges.
I do understand why members will feel frustrated in this case. I have the greatest sympathy for the victims. My team and I can see firsthand the devastation that scams cause to people's lives. And I would say in this particular case, as in all our cases, we do talk to victims, we gather evidence from them, and we take personal impact statements from them to put before the court when the sentencing, as happened in this case. So we made sure the judge was aware of the impact that Mr. Garner's offending had on the members, and indeed the judge's comments and sentences reflect that. But ultimately, in the prosecuting decisions we make, we have to be led by the evidence. So just to, also to add, as the Pensions Ombudsman mentioned, the standard of proof is different. They would have to show on a balance of probability that there was dishonesty. We would have to prove it to the criminal standard beyond all reasonable doubt.
Yeah, but you could have had a go, and you didn't.
Well, I'm not sure I can add a great deal to my colleagues' comments. I mean, the only other thing I would also add is that dishonesty doesn't necessarily equal fraud. I'm sure the committee aren't suggesting that, and there are other elements to that offence that would need to establish to secure a conviction. So, for example, the intent on the party to cause loss or gain as a consequence of their abusive position. So, although obviously the Ombudsman found that dishonesty, it doesn't equal the criminal standard either, or the offence itself of fraud.
Looking at what the judge said at the time, the absence of dishonesty was something that he emphasised that was not part of the deal, and the sentence would have been significantly different if dishonesty had been part of the indictment, but there it is.
Can I just pick up Sir Devlin's point? I mean, you could have gone with both, couldn't you? What would have been the downside of pursuing a dishonesty, fraud prosecution alongside the employer-related offences prosecution?
I mean, it's incumbent as a prosecuting authority to consider the strength of the evidence as to the appropriate indictment that you lay. I mean, as I said, we looked at the evidence and took a view as to what the appropriate case to take forward was on that basis.
Sorry.
Oh, so can I move on to the Financial Compensation Fund now? Again, the Pensions Ombudsman made his finding of dishonesty with respect to Ghana in June 2020. Why did it take the fund till March 2023 to reach an in-principle decision?
I'm assuming that question's for colleagues to my right.
Yeah.
So in June 2020, we were still in the midst of a court hearing to clarify whether these kinds of pension scams could actually be eligible for compensation from the Fraud Compensation Fund. So that clarity came in November of that year. And then it wasn't until September 2022 that we received evidence from Dalriada in respect of the Norton case. They had first drawn it to our attention back in January 2020 alongside 100 pension scam cases. So for Dalriada, there was a question of prioritisation of those cases. As I say, they first presented evidence to us in September 2022, and we reached that decision in March 2023, so 6 months later.
So are you saying that you can't just accept a finding from the Pensions Ombudsman? You've got to go through your own determination?
Yes, that's correct. I think it came up in the previous evidence session. There is a slightly different test for us to be able to pay out compensation. I think it's important to flag that or to recognise that, of course, we take, if there has been a prosecution or if there has been action like the Ombudsman's, then we, of course, take into account the information that's been provided. The test for us is that there are reasonable grounds to believe that there has been a dishonesty offence and that it's caused loss to the scheme. So it is a slightly different test. It's not a what we have found is it's not a hugely difficult test to satisfy in the cases that have been coming through. Of the cases that have actually applied to us in the big batch of cases that Sara's talking about, we have all the ones that have gone through that process. We have ultimately found that dishonesty test to be passed, and it's not massively holding up that process. There are, as Dominic said earlier on, there is a whole pile of hurdles that we have to get through, of which this is one. So yes, the test is slightly different, but I wouldn't want to overemphasise the extent to which that makes the process difficult. Since the 2020 case, where it became apparent that where it was clarified that we would have to pay out on these claims, and therefore government lent us money in order to be able to pay, and all of that stuff. What we have done is looked at all of these different kind of hurdles in the legislation and tried to find practical ways to get through them as quickly as possible, given that it's such a terrible situation, and the members have already been waiting so long by the time the application actually gets to us.
To just clarify in terms of progress, we've made that decision that dishonesty has taken place in relation to 85 schemes so far. We've made 26 substantial payments, but where there may be top-up payments to come, and we've completed payments to 2 schemes that have now reached members, the Endavis and Speedy Loan schemes.
Last week we were told that it would be a significant improvement if the fund were able to start making payments much earlier, with recovered assets being assigned to the fund. Would that be possible without primary legislation?
I think you're referring to the question of, do we have to wait for all recoveries into the fund? because we are a fund of last resort. So the legislation does say that we can't pay out until all kind of reasonable recoveries have been made. Again, that's not a sort of no stone unturned process. We apply the expertise that we have internally to encourage the trustees to bring that to a conclusion quickly and not pursue pointless avenues. We are currently kind of, again, working within the existing legislation to say, actually, we can make it a condition of the money we pay out that that if there are any further recoveries into the scheme that we get the money back. And we are looking at the prospect of taking an assignment of those claims, which is sort of, again, along the lines that I think the witness last week was talking about. So to actually formally stand in the shoes of the creditor, which I think is what was being suggested, I think it would need a primary change, but I think we can largely affect the same outcomes within the structure that we're using at the moment.
If I could perhaps give a practical example of that. So on the Pablo schemes, where we first received evidence in February 2022, we were really helped by some convictions that the regulator had made against the trustees in that case for fraud by abuse of position, made our dishonesty decision in August 2022, and paid out £13.2 million in November 2023. There are assets still due in from those cases, and we've made it a condition that should recoveries subsequently come through, they will be transferred to the Fraud Compensation Fund. So I think that demonstrates the point that David's making, that we're already in a position where this doesn't need to hold us up from getting that compensation through to schemes and subsequently to members.
Thank you very much. Celine Saxby.
Thank you and good morning. To what extent will the Fraud Compensation Fund put Norton Pension Scheme members back in the position they would have been in if there had been no dishonesty?
To a very large extent, so we will pay out in full for the loss of those members.
Thank you. And is it fair that they will miss out on the growth in their pensions that would have occurred had they not been victims of a scam?
So we have to calculate in accordance with the formula set out in legislation, and that allows for the loss in terms of the money that members originally transferred into the scheme, but there is no allowance either for inflation or for investment growth. That would require a change to the law.
Okay. So 9.4 million has now been paid to Dalriada as of the 10th of this month. So why is it taking until November for scheme members to get the money that they are owed?
So one of the principles that we think is important is that members shouldn't be overcompensated for their loss, so they shouldn't receive money twice over. And we know that in the vast majority of these scams cases, members did receive some of the money from their funds when they first transferred. And so now we need to understand the extent to which members have already received money from the schemes, and so Dalriada will now be writing out to the members of the Norton schemes to establish that, and as soon as we've got the facts, we'll seek to make a top-up payment so that payments can move through to members.
But given that this has been ongoing for some time, why hasn't that work already been done?
That's a very reasonable question, and we would anticipate that going forward, as soon as the Fraud Compensation Fund determines an act of dishonesty, trustees will then get on with the work exactly as you describe. Unfortunately, the legislation in this area isn't clear. The moral argument is, but the legislation has proved tricky, and so there have been extensive discussions between us and trustees to get comfortable with the right way forward. We've now reached a conclusion, and that will enable the member right round exercise to happen. But again, to give you an example, our biggest claim to date, the 5G scheme, that will claim perhaps up to £28 million, 530 members. The right round exercise is already happening in that scheme, even though we have yet to make the first payment, and that is exactly what we would like to see going forward. There's no reason for delay once we've found that an act of dishonesty has taken place, and as has already come up, there's legislation in place now to allow us to make interim payments to trustees, so if assets have been depleted, we can fund the costs of those right round exercises once the decision of dishonesty has been reached.
And given the evidence we had earlier this morning about the level of distress that this has caused those people waiting on this money, is there any opportunity to speed up this process, given that they now know that the money that is owed to them is actually sat with Dalriada?
I think in this particular case, we will move as quickly as we can, and we will support Dalriada every step of the way, because we absolutely agree with you that if I were a member, I would think there's no acceptable time now to wait until I receive my compensation. We'll be working with them. I think what we've also been trying to do at the systemic level is to find our way through legislation drafted 20 years ago that's not ideal for these circumstances, but to be flexible and pragmatic to find solutions so we can move cases forward as quickly as possible. And I think that is demonstrated by those 85 decisions of dishonesty I referred to, the 26 payments, the 2 payments in full. We're really now moving at pace through the pipeline of scam schemes. We committed in our strategic plan to complete the majority of cases by March 2025 and the remainder by March 2026, and we're on track to achieve that.
Thank you. Thank you, Chair.
Thank you very much. In the case of Norton, has the whole payment now been made to the trustee?
So we've paid the majority, but the maximum claim would be £12.9 million, so some additional funds there, and this really depends on the extent to which members had already received funds from the scheme, right, which will determine the extent to which we top up the 9.5 million that we've already paid.
Right. So previous to the clarification which you just told us about, the trustee wasn't able to seek this information about previous payments to members. Is that correct? Or
had they been comfortable that that was the right thing to do, then yes, they could have sought that ever since we reached our decision of dishonesty back in March 2023. But because the law is unclear, there were some important discussions that we needed to have with the trustees to get them comfortable with the approach that needs to be taken. They are now comfortable and they're proceeding, and as I mentioned earlier, on 2 cases such exercises have already been completed successfully. There was an excellent participation rate from members. Members came back quickly, and the money has reached members, so we're confident that this is an approach that can work in practice.
And when was this resolution getting everybody comfortable? When was that achieved?
Very recently.
Last couple of weeks? Or?
Yes.
Ah, okay. All right. Can I just turn back to the pensions regulator? I mean, you've explained to us that you had a whistleblowing report in 2013. You didn't at that point pursue it. If you had decided then to pursue it, is it right that you would have had the basis for a prosecution on these employer-related investment grounds as early as 2013?
Yes.
Having decided in 2013 not to pursue the matter any further, did you keep Norton on any sort of watch list, or was the kind of the file closed and not opened again until you got the 2017 whistleblower report?
So just to clarify, the 2013 whistleblower report related to conflict. The 2017 whistleblower report were related to employer-related investment, just to be clear. So I'm not aware that there was any active casework or monitoring of the scheme after that point, or between those 2 dates, rather.
Right. But if you'd investigated in 2013, you would have found these employer-related
With the benefit of hindsight, of course, yes, we would have done.
Can I just add that our approach at the time was not to take our own prosecution, so we would have referred them to Action Fraud or other law enforcement agencies. We now have our own internal capability to take criminal investigations and prosecutions, but we didn't have that until around 2018.
Right, okay, thank you. Can I ask about a couple of other points? Defined contribution master trusts are stringently authorised, unlikely, they say, and probably correctly, to trigger claims to the Fraud Compensation Fund. But if costs go up, the levy increase will fall disproportionately on them. Do you agree that the per member levy means the burden does fall disproportionately on mass market auto-enrolment schemes that are used by low earners?
We're very aware of that debate. Ultimately, the maximum levels of levy for ordinary schemes and DC master trusts are set by DWP, and at the moment, given the situation, in terms of the rate at which we're paying schemes out, we are simply charging the maximum levy that we're allowed to within those caps. The DC master trusts pay since 2022. They've paid a lower per member rate, precisely for the reason that you describe. Previously, it was the same all the way across. They are, I think they've got a good point that they are lower risk. They're probably not zero risk. The FCF was set up really for frauds going on in otherwise perfectly legitimate, well-run schemes. So where the level is set in terms of the relative levels for the two schemes is a question for DWP.
It perhaps is worth mentioning, though, that we're looking at two cases at present that we do believe are master trusts within our existing pipeline. So while we would absolutely agree that they would generally represent low risk, I think that evidences the point that the risk is not non-existent.
Right. But there is a case to be made to DWP that the current levy is unfair to DC master trusts.
I don't think we would particularly have a view. As I say, from our point of view, the critical thing is that there is enough levy to make the payments.
Okay, thank you. The regulator, together with the fraud compensation fund, is putting together, we understand, a list of orphan schemes with no trustee that might make an application to the fraud compensation fund. Can you tell us how many are there? Do you think you know about all of them, or are you looking for more? What's the picture there?
Pass my colleague.
Yeah, I'm happy to take that. So yes, as you say, we have been working very closely with the Fraud Compensation Fund for the last around 2 years, but also with the Pensions Ombudsman, because they will be aware through member complaints of schemes that we might not have on our list, and we have been building up this list of orphan schemes. So we're currently aware, putting aside the ones that are already on the FCF pipeline, which have been mentioned and they're already going through the process. We at the regulator have 13 schemes where we're actively investigating to...
Sorry, is that 30?
13.
13.
Yes, 13, where we're actively investigating and looking to appoint a trustee.
And sorry, that's on top of the 100, did you say?
Yes, that's on top of the 100. And we are aware of another, at least 24 orphan schemes, so schemes without a trustee, and we will be working our way through the list. We are recruiting additional resource. We had some money from DWP in relation to the Pension Scams Action Group to increase our resource in this area, and we will be using some of that to help us work through the pipeline of schemes and appoint trustees to these legacy schemes. To be clear, these are all old legacy scams where there's no assets in the scheme or the employer, and the only route is through compensation from the FCF. We're fairly confident that we know of most of them. However, we are constantly building our intelligence picture, and there are occasionally schemes that come to light. Sometimes the trustee, whether it's Dariada or another trustee, when they are appointed to one scheme, they might find information about another scheme that is linked that we didn't know about. As you can appreciate, a lot of records are non-existent, or the processes for registration, etc., haven't been followed. So we do sometimes find out about new schemes that we didn't know about.
So you mentioned 100 plus 13 plus 24, 137, but you are looking for more, or at least alive to the possibility there could be more.
Yes, that's right.
Yeah. Do you have a feeling for what the upper limit on it is going to be?
I'm not expecting us to find a lot more, so there could be a handful more. And as to the earlier questions around current live scams, we're definitely not seeing too many of those. Obviously, we mentioned there is a recent case, but it's the exception. We're not inundated with live scams at the moment.
Okay. And how will you encourage professional trustees to take on these orphan schemes? And for example, would Dariada suggested to us that prior assessment of eligibility for the Fraud Compensation Fund might...
Yes, so this is one of the things we are working with the Fraud Compensation Fund to do. So for some schemes where we're able to investigate between us and uncover evidence that there has been dishonesty, then the FCF can kind of give a preliminary view that there would be dishonesty, and that gives the trustees some comfort that they will be able to have their fees paid out of the
so that
compensation.
procedure ought to be in place, should it?
Yes, this is what we're doing at the moment. Yes.
You're working on it, or it's in place at the moment, or?
We've already used it on one case, for example, Salmon Enterprises, which I think you may be familiar with. So we at the FCF did a high-level investigation between October and December of last year to provide some confidence to the regulator and to any trustee firm that might consider taking the case on, that we think there's a strong chance that dishonesty can be proven in the case. And we let the regulator know the results of our investigation at the end of December, and I think you'll be appointing a trustee shortly.
Yeah, this is one of the 13 cases that I mentioned.
Right.
Does this change the fee schedule you'd expect to get in the tenders, because the risk of not getting paid drops away very substantially at that point, doesn't it?
That is an interesting point, and something we'll be picking up as part of the tendering process. Ultimately, we have to allow a competitive process to take place, and we look at all the tenders that we receive to see what is the best value for money. We don't just look at costs; we look at the trustees' skills and expertise. But it is a competitive process, so we'll be scrutinising the fees put forward as part of that process.
Presumably you'd expect more people to be tendering if there's a much higher chance of getting paid. That would be a good test to whether the market's
like to hope so.
You.
I mean, it's a much better market if it is competitive in that way. So we'd like to hope that trustees on our register would be coming forward to take these appointments.
Maria, how long do you think it'll take to work through that pipeline that you've described to us?
The 13 plus 24. It's difficult to say because I don't know, particularly for the ones that we haven't started investigating yet, what complications we might find in terms of evidence. It's a much quicker process in some of the cases. For example, the Salmon case, because we've already got the finding from the FCF, and some other cases we already have findings from the Pensions Ombudsman, so we can use their evidence and their findings, and it's a much quicker process then to do the
So do you expect to finish this year, next year?
I don't think it would be this year, but hopefully within the next couple of years.
Within the next couple of years. Okay, thank you. Just finally, Sara, you mentioned what sounded like a very large a case which I haven't heard of before, 5G.
5G, that's correct.
Can you tell us what that is about?
Yes, so that was actually the first case that we became aware of this type of scam scheme back in January 2015. And as I mentioned, it has 530 members, a claim of up to 28 million and 30 investments. So it's a really complicated case for us to make our way through, but we are almost there, and we expect to make our first and most substantial payout on that case by June of this year at the very latest.
And this was a scheme that was set up to defraud people, was it? Or I mean, what was the 5G scheme?
I must admit, I don't personally know details of the scheme, but we could absolutely follow up with the committee if you'd like to understand it further.
Okay, I think we would be interested to know a bit more about, given the scale of it, what was going on there. Yeah.
Absolutely, very happy to do that.
Okay, well, thank you. That concludes all our questions. Thank you very much for joining us this morning, for the helpful answers you've given us. Order, order.
The proceeding has ended. 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 The proceeding has ended.